5. We have the plaintiff Jenny Curaconi present. We have the defendant Justin Guadron present. Sir, are you, do you own Affordable Land Care LLC?
Yes, ma'am.
All right, he is the owner of the other named defendant, Affordable Land Care LLC. So I see that there has been an amended claim filed in this matter. Let me go ahead and make sure that all the parties are aware of this new amended value. Have you received that, sir, the amended claim?
I haven't received any paperwork, no.
Well, how do you know to be here today, sir?
Well, I received paperwork previously, like months ago, or weeks ago. I'm sorry, I'm busy, so I lose track of time. But I haven't received paperwork for this court date today. I called you guys at the district court and followed up on I looked up the dates and I was just following the trail, but I haven't been served proper paperwork yet. No.
Well, I have right here, and I just want to make sure that everything is correct. I have right here that a proof of service. It says here that you were personally served on February 2nd, 2025 at 1:30 p.m. and that you were
And
served.
that was on a Sunday.
Yeah, I'm not
Yep,
quite sure.
that's the one I was served, but there were no court dates on that paperwork. It didn't say, "Hey, you're at this date," and it didn't say what. There was no exhibits. There was nothing attached to that. I didn't know what I was being sued for other than what was on that paper.
1 second. Ms. Curaconi, did you file proof of service on the amended claim?
I attempted to, Your Honor. And in fact, yesterday I delivered to the court proof that I engaged Emerald Legal Service down in Eugene, and they attempted many times to serve Mr. Guadron, and that he refused to open his door on many occasions. There is something that they call a proof of due diligence as well.
By mail, by personal service, or by substitute service. So if they have been attempting to do it, then you would need to just serve him by certified mail, because at this point we don't actually have proof of service of the amended claim. I will agree, I do accept. All right, but that hasn't been filed, ma'am. I don't have a proof of service on my end. I see that you have that form, but I have a defendant here saying that he didn't receive the amended claim.
He did not receive the amended claim, Your Honor, because he has refused to open the door to the personal service representatives trying to serve the amended claims notice.
And I hear you, ma'am, but unfortunately he does need to get that serviced. So you can do that by certified mail, and that would be sufficient. He doesn't need to be served by an individual then.
When I have done that before, he refused it. He refused it to pick it up for over 30 days. That's why I used a service to inform him of the February 2nd one.
Well, you know, it can be left in a mailbox too.
I will attempt again, Your Honor.
Okay, all right. So, sir.
Today's case is a perfect storm of courtroom drama, entitlement, and a plaintiff who seems to believe the legal system exists purely for her personal satisfaction. Meet Jenny Curacone, a self-proclaimed litigious Karen who, according to the court, has made a habit of suing people around her whenever something doesn't go exactly her way. In this first part of a two-part saga, she's taking a contractor to small claims court over a kitchen remodel she claims went wrong. But as you're about to see, this isn't just a simple disagreement over construction work. From emotional outbursts to procedural mistakes, and even attempts to blame the defendant for not being properly served paperwork, Jenny's courtroom behavior quickly becomes the real story. Meanwhile, the contractor is juggling work, parenting, and multiple court appearances, trying to keep up as the plaintiff keeps amending claims and shifting arguments. And if you think this first hearing is wild, just wait, because the second part somehow gets even crazier.
you are here, you followed the trail of dates. You are now aware that you are going to be served an amended claim.
What address is she mailing them to? Because I have moved. I'm a single dad and I had to relocate to be near my kid. So
Sure,
she
Ms.
might be mailing
Piraconi,
them to the wrong address.
what's the address that you're trying to serve, please? Ms. Pir-
It should be on the paperwork from the service, Your Honor. I do not have that paperwork right in front of me.
I don't have a proof of service for the amended claim. For the small claim, it is,
Yes, you do not have proof of service for the amended claim because the defendant has refused to open the door to Emerald Legal Service of
ma'am,
Eugene.
I understood.
Okay,
And I
okay.
understand.
And I
just-
understand he can also refuse to pick up the registered mail, certified mail. I will attempt to do that again, Your Honor, at his Eugene address.
That is not what I'm asking, ma'am. I'm trying to find the address to tell him. And I said, I don't have one for the new
All
proof of
right,
service. I
yeah.
will look at the old proof of service. And I'm asking you, is that the same address you are trying to serve?
No, Your Honor. That address is open.
Well, Eugene, Oregon.
Eugene,
971.
Oregon.
Is that your address, sir?
Yes.
Okay. All right. Well, you're now put on notice that you are trying to be served this amended claim. At this point, there's really no reason for you not to accept service of it because we do have proof of service on the small claim. I don't think there's any difference. So the original claim is asking for $6,000 in reimbursement, and the amended claim is asking for also $6,000. So not an additional, but the same amount.
Okay.
So
what does it say? What are the accusations?
well,
What
I
is
need you to accept that. It says right here, cost of permit and inspection costs to remediate items, failing inspection, post to complete work left undone, including labor and materials, cost of cleanup. So,
Well,
sir,
can we avoid time and just enter court now? So we
no,
can just, or
I
do I
don't have
have to wait
time. I
for
have
her?
a trial in 5 minutes. So
Okay,
today's
so I still
purely.
have to wait for her to serve me?
Yeah, so she needs
Okay.
to serve you, but we can set up a trial date right now. I just want
Already seeing the judge gently try to keep things professional while the plaintiff's emotions are bubbling over. And that quick comment about not commenting on that is judicial language for, this is already getting out of hand. When a judge points out emotional behavior this early in a hearing, it's usually a sign that the court expects trouble ahead. Small claims court is meant to be straightforward, present evidence, explain damages, and let the judge decide. But when emotions take over, cases often spiral into chaos instead of clarity. And based on what the narrator teased, this meltdown is just a preview of what's coming. What's interesting is that judges often give people like Jenny a bit of rope at first, staying patient, letting them talk, and hoping they'll calm down. But as you'll soon see, patience only goes.
Guadrone, if you could please unmute, take off your hat, and just drop the. Mr. Guadrone, what is your background, sir?
It's a picture of the kitchen that we did some work on, and since this court case we had with you, I found out that it's being broadcast on YouTube and over 37,000 people are watching us, so I figured I'd put that up there so we can.
All right, sir. I did see an exhibit you submitted, and I am aware that this is now likely being streamed on YouTube. If you could please take down your background, I don't appreciate me being broadcast in the background in a picture like that. Thank you, sir.
Let me see if I can figure out how to do it while we're working here.
I'll wait until you can figure it out, sir.
Does that work?
That's great. Thank you, sir. All right, so we're here in case 24S235. We have the plaintiff, Jenny Quiriconi, present. We have the defendant, Justin Guadrone. Are you the owner of Affordable Land Care, sir?
Yes.
Okay, the owner of Affordable Land Care. So It looks like an amended claim was filed, but as of today, sir, $6,000 is being requested by Ms. Quiriconi against you. Are you aware of that value?
Yes.
All right, sir. So, sir, you keep popping in and out. I don't know if you could just stay in the camera, please.
I'm sorry. I'm at work.
All right. Well, this is a trial. So
Yep.
I apologize that you're at work. You're just going to have to take some time off to handle this matter. All right, sir. So going forward, this is a trial. Ms. Quiriconi is going to go first. She is the plaintiff in this matter. I'm going to let her go first, present the evidence that she has for the $6,000 value she is seeking against you. If she has any witnesses to call, she can call them forward, and then we will listen to her side of the story. When she's done, I'll let you tell your side of the story, sir. I ask that both parties do not address the other, that they only address me. If there are any questions, just to me, let's try to keep this amicable. I don't want this to be a contentious situation now that you have brought to light that most people on YouTube like to watch Ms. Quiriconi's matters. So let's just keep this very amicable, please. When you're done, I'll go ahead and.
Here's where the case immediately runs into procedural trouble, and this is something that trips up a lot of people who represent themselves. In court, it's not enough to just file paperwork. You have to properly serve the other party, meaning they must legally receive notice of exactly what they're being sued for. The defendant admits he received earlier paperwork but not the amended claim, and that's a huge issue. Without proof of service, the court legally can't move forward on the updated case. It doesn't matter how right the plaintiff thinks she is. If the paperwork wasn't served correctly, the judge's hands are tied, and notice how Jenny keeps shifting blame, saying he refused to open the door, refused mail, and avoided service. Whether that's true or not doesn't change the legal requirements.
Your court has been monetized on YouTube, that I have been subject to harassment by
It's not monetized. How is there any monetary financial gain from this?
the people who stream your court on their YouTube channels have paid subscribers.
What does that have to do with me, Ms. Quiriconi?
I am just stating facts regarding your channel being monetized.
It's not a channel. I'm a government employee sitting in a courtroom. This is not a YouTube channel. This is a Zoom trial.
This is true, Your Honor. And people on YouTube are monetizing the picture of my kitchen in his background.
All right. Mr. Guadron, please take it down and make just a neutral background. That is an exhibit that has been submitted, and I will go ahead and review it at another time.
Can you see? I just want this exhibit that's in my background is pertaining to the case. Wasn't able to give it to you in the photos. I wanted
Okay,
you
well
to
then
see
please take
this
it down. Please take it down.
because it goes against one of her allegations.
All right, so you're going to have to just testify against to that verbally at that point, please.
Here, service can be done by personal delivery, substitute service, or certified mail. These are standard legal methods designed to make sure both sides get fair notice. And instead of simply following those instructions, Jenny keeps circling back to how difficult it's been and how the defendant allegedly keeps refusing, but courts don't operate on frustration. They operate on proof. If someone won't answer the door, you use certified mail. If they don't pick it up, there are still procedures to document attempts. What the judge is basically saying is, stop arguing and follow the rules. This is a pattern you'll notice with frequent filers. They're quick to sue, but often sloppy with procedure. And those procedural mistakes can completely derail a case.
Your Honor, last year, I contracted with Justin Guadron and Affordable Land Care to have my very small 9x10 kitchen remodeled. I paid my invoices, and within the exhibits you will find representations of my checks that he accepted in full payment of the first 2 invoices generated by him. There are no details of how much labor might be required in hours. And in fact, I did not ask him at any point for documentation on hours. And that is one of the questions that I have for Mr. Guadron, is if he can supply documentation for the number of hours and the days that he worked.
Quiricone, I apologize. Mr. Guadron, this is a trial. Please take off your hat. Please do not drink beverages, and please do not eat any food. This is a serious matter, sir. Thank you.
I'm sorry.
Ms. Quiricone, please continue.
Thank you, Your Honor. Because of the nature of the work, plumbing was required. I have since found out that while Mr. Guadron is a plumbing contractor and a general contractor, he is not a plumber. And from the very beginning, he put himself forward as a plumber. A plumber must have that qualification through Labor and Industries. Mr. Guadron is a plumber trainee, and as a plumber trainee, he is required to have supervision on site for his work. To my knowledge, he never had supervision on site. Within the paperwork is who is supposed to be supervising him. I was unfamiliar with that name until I started looking, and I never met anyone named Patrick. I never heard their name, nor did I ever hear the name of the person who was supposed to supervise him. I was not on site the entire time that the plumbing work was being done. However, when I was here and plumbing work was being done, there was absolutely no supervision whatsoever. Mr. Guadron claims that there were, according to his document, unexpected circumstances. But his document also says that his labor is warranted for 1 year. That year is not yet up, Your Honor. I have had an estimate done of what it will take to remediate the items in my kitchen that are substandard, do not pass inspection, and I have requested be fixed by Mr. Guadron. He has refused communication. He has done shoddy repair work. Behind me are 2 full tiles of flooring that were available to properly repair the floor. Instead, he put in a little plug in the flooring that has a hole all the way around it, and in the center, they go straight through the subfloor and into the insulation. In the picture showing that, there are numbers 1 and 2. 1 shows the pipes passing from under the cabinet and into the floor. Plumbing regulations require that something like this item, I believe it's called an escutcheon, this one was made in 1914, go around those pipes and secure them to the floor. This prevents my plumbing from passing inspection, an inspection for which a permit was never obtained. If Mr. Guadron is a plumber and a plumbing contractor, he ought to have gotten the proper permit to do the plumbing work. He did not acquire that permit. I do not know if he got permits for remodeling. I have not checked. I never saw one. The only permit I ever saw was for electrical, and I paid for that. If you notice in the picture where the floor has been repaired, you will also see at the back of the wall, there are no baseboards. This means should any pipe burst, should there be any kind of leak whatsoever, that water is going to go down there at the base of the floor, ruining not only the sheetrock behind it, but possibly the underlying subfloor The insulation.
Defendant explains that he's a business owner, a single dad, and split between 2 states, which makes service attempts more complicated. But instead of acknowledging that reality, the plaintiff seems convinced that every missed attempt is some kind of intentional avoidance. This is where prospect courts understand that, which is why service rules exist to account for real-world SIE. Judge even points out that the amended claim doesn't change the dollar amount.